Hello, my name is Eric Hanscom. I'm the managing attorney at Intercontinental IP, and I'll be your instructor today for this course on patents, trademarks, and copyrights, and how intellectual property can help inventors protect their ideas. We're giving you this course from Thai West Resort on Koh Siboya Island in Thailand, and so we'll have some nice scenery, and hopefully you'll enjoy the class. So again, thanks for tuning in. We're going to be going over patents, trademarks, and copyrights as the three basic tenets of intellectual property. What is intellectual property? Well, intellectual property is something you own that's up here. We have real property laws to protect your right to own a house and keep other people away. We have personal property laws so that people can't take your watch or your car or something like that that you own personally. We have intellectual property laws because what you have up in your brain is something you can own and it's something worth protecting. So let's talk a little bit about the three types of intellectual property we'll be covering in this class. The first is going to be a patent. And what does a patent do? Well, to quote the statute, a patent gives you the right to exclude others from making, using, or selling the invention in the country in which the patent is granted. What does that mean in real English? Well, it means that you have a limited monopoly over your idea. And the reason that there are patent laws is that if you couldn't own what you invented, there'd really be no reason to be a scientist or an inventor or have an R&D department. So there'd be an awful lot of people out of work if people couldn't protect their ideas. The next type of intellectual property we're going to be going over is a trademark. Now, a trademark's a little different from a patent in that a trademark protects the identity of a source of goods so that consumers are not confused as to which product they're buying. So unlike a patent that protects your idea, a trademark protects a business identity to the point where other people can't then produce a knockoff or a counterfeit product that so closely mimics the name or the appearance of the logo or the slogan or something like that relating to the business that people are confused as to which one they're buying. The last type of intellectual property we're going to cover is called a copyright. Now, a copyright is different from a patent and trademark in that it doesn't protect an idea. It doesn't protect a particular name or slogan or business identity, but instead a copyright protects a work of art. Now, a lot of inventors immediately turn off their ears when they hear work of art because they figure, okay, well, copyrights are just good for movies and collections of photographs and songs and things like that. Well, they are good for those things because those are all artistic works of art that can be protected by a copyright. But for you inventors, a copyright can also protect things such as your website, which is one of your most valuable pieces of property as an inventor, is the website that then portrays your idea to the rest of the world. You can also use a copyright to protect your owner's manuals or brochures, anything relating to the sale or the promotion of your product. So as an inventor, don't forget about copyrights. When we deal with copyrights, one of the common urban myths, I guess we could call it, is that once you've created something, you have a copyright that gives you universal protection for everything related to the invention. Not quite true. When you do create something, you do have a common law copyright on it. The problem is that to enforce that common law copyright, you have to prove the damages to yourself as well as the unjust enrichment or whatever benefit another party got from having taken your copywritten materials. It's much better to get a registered copyright because with a registered copyright, rather than having to prove anything in court about the damages, you instead can rely on a theory called statutory damages where you can ask for up to $150,000 for a knowing and willful infringement. And a knowing and willful infringement has been determined by recent court decisions to basically be Control-C, Control-V. If you copied it, you knew you were doing something wrong, so statutory damages. Now, you don't end up with $150,000 most of the time. Usually you end up settling these cases down to $20,000 to $60,000. At the same time, it's much easier to start with an infringer by saying, okay, we're going for statutory damages. We started at $150,000 and we can try to negotiate that down if you want, as opposed to, well, we don't have any protection other than the common law copyright, so if we go to court, we're going to have to spend tens of thousands of dollars trying to find what your damages really were. It's much better to begin with statutory damages, which is why you want to register your copyrights. What kind of things should an inventor copyright? Well, again, if you're an inventor, anything that's an artistic creation is something you can copyright. So the most important thing, of course, is your website. copyright the website. Now, the copyright on the website is going to protect that particular snapshot of the website taken that day. So if you change everything a week later, your original copyright is probably not going to protect very much of that website. So what you want to do is you want to file a new copyright whenever you make a major change to your website, or particularly if you add, say, a lot of new photographs or new pictures of your product or new text. Our experience has been that oftentimes competitors will steal pictures, and they'll steal things like frequently asked questions. That seems to be the favorite thing that they steal, because they figure, well, whatever they're asking this person, they're probably going to have the same questions about our product. So rather than make up our own frequently asked questions, we'll just steal theirs. So anyway, those are particularly the areas that are copied most often. So they're areas that you want to look at protecting. So again, get a registered copyright on your website. Also, your packaging is very important. Your packaging is indicative of the source of goods, so it could also be a trademark issue, but in terms of copyright, you can copyright your packaging, and you can do that because oftentimes, especially if you're having your stuff made overseas, if somebody finds out where your factory is and they get your factory to make their product as well as your product, there's a significant chance that they're going to use a lot of your packaging for the competitor's product. So probably a good idea to copyright the packaging as well. And last but not least, any kind of advertising brochures, trade show, giveaways, anything like that, those are all things that you can copyright as well.